Oyez, oyez, oyez. All persons having business before the Honorable the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3058. United States of America versus Joey Green-Remache, also known as Joey Green, appellant. Mr. LaCar for the appellant, Ms. Part for the appellee.
Mr. Decker, before you begin, let me just say to everybody arguing this morning, the reason we're late coming in is this sound system for several of us is being worked on, but it's very hard for some of us to hear.
Me too, Your Honor.
Okay, well, then you know, if you would adjust counsel, if counsel would adjust the podium anyway, you need to, and get as close to the black bar microphone as you can.
I'll do my level best.
Okay. Mr. Lecco?
Thank you, Your Honor. May I please report? So for government and Mr. Green agree that the normal rule in this circuit, when ineffective assistance of counsel is raised for the first time by a new counsel who was not involved in the trial proceedings below, that case will be remanded for a factual hearing for development of a record unless the following exceptions occur. That the case is, the theory is legally foreclosed, which isn't the case here, or the facts conclusively show that the appellant is not entitled to relief, which is not the case here, or that the law is foreclosed, the theory. And we have cited a number of cases, primarily at the district court level, that support our theory that it was error not to seek a Dalbert hearing, not to move to strike the expert's testimony at the conclusion of her testimony.
Counsel, are you suggesting that generalized testimony can never be allowed?
Can
never be allowed. Generalized testimony from an expert about a particular subject can never be allowed.
Oh, there are circumstances where it can be allowed, but it just wouldn't happen in this case for the following reasons, Judge Childs. There was no record below, and there were viable claims that could have been raised as to the expert's failure to apply her knowledge reliably to the underlying facts of the case. She knew nothing. But if
you look at the record, and I was very concerned about that myself, that one, we would allow generalized testimony. Two, we would make sure that the testimony mattered in the case as to the facts presented and not so general that, for example, in a domestic violence case, you wouldn't allow them to say, and then their perpetrator could continue on this line of assaulting them and then they'd be dead, if that wasn't the facts of this case. So as I read the record, I feel like she stayed within her lane to only address issues that were here, but never opining on the ultimate issue.
I respectfully submit that your court might take a look at pages 21 through 24 of our brief. And let me give you some examples. She testified to this phenomenon of coercive control relationships. She said they're characterized by the victim, and it's quite clear that she meant the victim typically being a woman, although she professed to be gender neutral on the issue. She said that there are 5 to 7 attempts to leave. There was nothing to that effect in the record. She said, for example, that there was sexual violence in the bedroom, typically in these relationships. There was nothing like that in the record. She said that in addition to that, when people are jailed, when alleged accusers are jailed, they tend to call their abusers are jailed. I'm sorry, Your Honor. They tend to call the victims and threaten them, ultimately threaten them. There's nothing to that effect in this case. There's alleged pressure from the victim's family and from the alleged abuser's family on the victim to recant. There was nothing like that in this case. Now, those should have been, there was no affidavit up front that was submitted in connection with the Dalbert motion. Counsel should have addressed up front and sought a hearing on the issue of whether Dr. Aghavan's proposed testimony reliably fit the facts of this case. I could not do better than to commend the court to the district court decisions in the opinions in Raymond and Gagne, and as well as Schneider. They really spell out the law pretty well. Now, I will submit to you, Judge Childs, there has been a trend in the courts to allow this sort of testimony. I think it's wrong. I think courts, the problem is at the appellate court level, as we said in our reply brief, there typically has been a Daubert hearing. There was no Daubert hearing in this case. And I need to address something about the theory of ineffective assistance of counsel. In my hubris, which is uncharacteristic of me, I said that the Sitzman case was, which the government cited, I said that it was unassailable in the result, because among other things, the appellant, in that case, the lawyer, who was the third lawyer on the case, there were two lawyers below, said that there was no need for a remand. I failed to note a dissent, a rather spirited dissent, by a member of this panel, which would support our theory that the case should be remanded for development of a factual record. The most glaring thing that we have in this case is that we have an expert witness who juries tend to trust expert witnesses. They have a special aura of respectability. In fact, the government counsel below in the closing argument talked about Dr. Aghaban as a, quote, incredible scientist. And she's giving you an explanation of all that's happened here, except that that explanation really overstated the relationship. This is a very strange.
Okay, let's take the expert witness out of it. You still have to prove that essentially your client would not have been convicted. We have other testimony, the victim's neighbor, Michelle Talley, the victim's roommate, Tyara Berry, who saw the defendant actually drag the victim out of her own apartment. And this is a case where there's a violation of a protective order. So technically, the defendant should not even be near the victim.
And
That's a valid observation.
I would add the marks of abuse that were on the victim, as well as the jail calls and her own grand jury testimony. Why can't we skip over the deficient performance and say there's just not a chance in the world this jury wouldn't have convicted him separate and apart from the expert?
Well, I think, Your Honor, what happened here is that if you view that no jury in the world could or would not have convicted, then I want to do my best to persuade you otherwise. Here's why. For every statement she made, there was a retraction. She's professed her undying love for the appellant right at the start. I grant you, I conceded in my opening brief, there was testimony from other people. However, the critical issue needs to be addressed here is what was his mens rea and what happened here? What was going on in his head at the time this alleged violation occurred of interstate transportation in violation of a CPO? There is testimony in the record, Judge Henderson and Judge Charles, that they had continued to, I don't want to use this word lightly, fool around. They stayed in contact, notwithstanding the protective order.
Including a jail cell call.
So the question becomes, what was going on inside his head? And we have a jury that's primed, that it can make its own conclusions based on common sense and its experience, rather than have a government put its thumb on the scale with somebody who doesn't know anything about the facts and who testified as to a number of phenomena, as she said, was characteristic of this sort of a relationship without ever having examined.
Okay, so the remedy you seek would be to remand and have a new trial. What is it that you would show differently? Because you still have this other testimony that myself and Judge Henderson are alluding to, other facts and evidence in the case.
There is that testimony, but you have to ask this, Judge Childs. You're sitting here essentially in a de novo without a factual record. There was nobody made a motion below for a Daubert hearing. Could he have been convicted just on that testimony alone without a Daubert hearing? Perhaps, but we'll never know. We will never know that because the government put its thumb on the scale by bringing in a so-called expert who knew nothing about the facts and was quite unabashed about knowing nothing about.
But let's look at the elements. The crime for interstate domestic violence requires only that the person who travels in interstate commerce do so with intent to kill, injure, harm, or intimidate, or attempt to commit a crime of violence, or cause travel of the victim by force. So it's almost a strict liability standard.
Intent, who makes that decision? That's the factual issue.
But when on the other side of that intent is actual physical harm, dragged out, physical evidence on the body, How do we not gauge intent from that?
Well, she said that the sex was consensual. That's what she said. First she said to
Dragging out of the apartment was consensual too?
what, Your Honor?
Dragging out of the apartment.
No, that's certainly, but that's not an element of the crime. The crime is taking it across state, is taking the victim across state lines and having violence at that point, is my understanding.
But I'm talking about the initial contact. They're not supposed to be in contact. You drag her out of an apartment. You started your crime.
And well, she said at trial, as you in the record, she also said that she went with him. He came in and she went with him.
We have a witness who saw it otherwise.
Well, I understand.
Okay.
The question becomes, and I see I'm running out, almost
You
run
can
out of
continue.
time.
Go ahead.
Well, thank you. The question becomes, was this trial elementarily appropriate, given the fact that there was an expert who was put on who knew nothing about the facts? And I think, I appreciate you giving oral argument in this case, because there is an important issue here working underneath this. Under what circumstances should people be allowed to testify as experts when they're talking about their experience? They're not talking about laws of physics, they're not talking about gravity, they're talking about human phenomena. It's almost like the Goldwater rule, in essence, indirectly diagnosing the field. I see that I've overstated my time, so
All right, we'll give you a couple of minutes in reply.
thank you, Your Honor.
Ms. Park?
May it please the court, Ann Park, on behalf of the United States. A remand for an evidentiary hearing is not warranted. Mr. Green-Remache has failed to establish a colorable claim that his counsel's representation fell below an objective standard of reasonableness and that the counsel's deficiency prejudiced him. Beginning with deficiency, federal circuit courts have routinely upheld this type of testimony, generalized expert testimony on the dynamics of abusive relationships and to explain specifically the irrational behavior or contradictory testimony of domestic violence victims. Trial counsel thus had no legal basis to challenge the admission of Dr. Raghavan's testimony, and he cannot be deemed constitutionally deficient for failing to raise meritless evidentiary objection. I'd also—
How do we deal with the fact that the jury hung on the kidnapping and burglary charges?
Yes.
Because we need to have defendants show that there would have been a difference in the outcome. And
Yes.
so you've got at least two charges that were not.
And this relates to the prejudice prong of Strickland. Kidnapping requires the government to prove, the government's argument is the verdict, the way the jury handed down the verdict, they only convicted on the interstate violation of protection order count. They could not reach a verdict as a kidnapping and first degree burglary. Kidnapping requires the government to prove that Mr. Green-Remache held or detained BP for some purpose or benefit. The government, in closing, and its theory of the case, was that the benefit he gained by detaining her was raping her behind the elementary school in Maryland. So the kidnapping incorporated the rape. And the rape, there was plenty of evidence, and it was not disputed that they had sex. The issue was consent. The only evidence, the only person who could prove that, so to speak, is BP. So her credibility was on the line there. The violation of protection order count, it was the only count that you didn't really need her testimony, because the assault, which defense counsel really did not dispute below as to what happened in the apartment, because Ms. Berry's testimony was so strong on that point. That was what showed the violation of the CPO. It also showed the use of force to cause her to travel across state lines. And I just wanted to make clear to the court, Your Honor was citing to interstate violation of protection order A subsection 1, which is not what he was actually charged with. It was subsection 2, causing travel of victim, which says a person who causes another person to travel in interstate commerce by force, coercion, duress, or fraud, and the course of such conduct engages in conduct that violates the portion of a protection order that prohibits or provides protection against violence, et cetera. That's what he was.
If you think the case, can you hear me? You can't. If you think the case is so clear, why did you need the alleged expert? The expert, there's no doubt the expert is helping you to tip the scale
Sure.
to the extent the prosecutor's got to worry about the recantation. The jury's going to be affected by that. So you agree the expert is going to tip the scales.
Sure,
That's why you put her in.
Sure.
Okay,
Expert would
there is-
aid the jury in understanding the evidence, because we have a victim who says one thing on the day of the incident and in her grand jury, and she says completely.
No, it's essentially telling the jury, in my expert view, he's guilty. That's essentially what happened. I mean, you understand that as a prosecutor. You all have been there a long time. You know that's exactly what's going on. So it's interesting that you're arguing so vigorously that the evidence is clear. He can't possibly win with or without the expert. Of course.
Well, I think with regard to this particular verdict, we could have won without the expert as to interstate violation of protection. The kidnapping, you look at the closing argument, a lot of the expert testimony was to talk about why the kidnapping was involuntary, and also why she didn't leave like at the 7-Eleven.
She recanted.
I'm sorry?
Why she recanted.
Yes, Your Honor.
That's what you're trying to get the jury to understand. Don't
the government's-
believe what she's saying.
Yes, that's what we're trying to get.
She's the victim. So that's
Yes, and
huge in a criminal case. That's huge. The victim comes in and says, it didn't happen. Well, you, the prosecutor, have got to be worried sick about that. But you're arguing like this is no big deal. You take the expert out, we're still going to win easily. You really believe that?
Yes, that's the violation protection.
Well, then maybe we should do what some of our cases have suggested, remanded for a hearing on this question. And there was no hearing. There was no Daubert hearing. It's kind of strange in this area because, as your opposing counsel said, it's not like this is science in some of the forensic areas, the decent forensic areas where there really is science to talk about. This is in an area where it's much more subjective and expertise is trickier. Why are you afraid of having the trial judge on a remand to go through it to see whether there's anything to be credited?
We're not afraid, Your Honor.
Well, then we should remand, as some of our cases. You have to be able to show a lot to block the remand, don't you? The remand, we're not talking about a win. We're
Yes,
talking about a
yes,
remand.
I understand. And I understand this court has said the general practice ordinarily, and Judge Kavanaugh in one of the opinions says it's a rare case where the court will not remand when you raise it. I understand that. And we're arguing that this is one of the rare cases.
I don't see the problem is I don't understand why, because this person clearly tips the scales and the trial judge would not necessarily, if it had been challenged, trial judge on this record, as I understand the law, was not obliged to allow it. There was no guarantee the trial judge after a hearing, if it had been challenged at the trial, it's discretionary. There's no
guarantee, but there is very strong federal circuit case law that has routinely and consistently upheld this kind of
that doesn't get you to a conclusion that the trial judge in this case on this record would have definitely admitted the testimony. We don't know that. Because it was never brought to the trial judges, It was discretionary. The trial judge would have had discretion to decide, based on what was presented, whether this person was being allowed to testify or not. You know that this person is critical. And so if there is that possibility, it's discretionary. The trial judge never considered the question, so it could go either way. There's no law that would have compelled the trial judge to admit her testimony. And our law is, as you say, now Justice Kavanaugh said, we normally send it back. We let that hearing happen. I don't understand why we don't send it back.
That's an ordinary practice, and I agree with that, Your Honor. But I'm trying to explain why we think this is the case that's one of the rare cases. I understand the admission of evidence is discretionary, but in the facts of this case and the nature of her testimony, the incredibly close fit between her testimony and the facts of this case, in federal court, these cases don't come up a lot, but certainly in state courts, this is actually very much the norm for domestic violence cases. A lot of times by the time of trial, victims are recanted. And this kind of evidence about what appears to be completely irrational behavior from people on the outside. Why didn't BP leave when the police get out of the car and get out of the car and try to get the police officer when she was at that 7-Eleven after he had assaulted her before the rape had happened?
Experts in this area normally want to know something about the case and the people before testifying about what they surmise.
But in this context,
no, wait, answer my question. Don't experts in this area, before they give their opinion, their expert opinion, want to know something about the facts of the case and the people involved before they sit up and say, well, in this situation, recantation is the norm. That's what she'll do. And it doesn't surprise me that she recanted
In this
without
case,
knowing anything about her or the guy or the facts.
the reason why she was brought, the government made clear, we were putting on general testimony. Courts have said consistently that it is okay. And actually, the advisory committee notes to the 2000 amendments specifically understand that the 2000 amendments, in light of Dober, did not change, they call it the venerable practice of having experts testify about general principles, because sometimes
You
that's
say
necessary.
general principles, but you're focused on coercive control and traumatic bonding.
Yes.
So there's at least some information that had to be relayed by the government to the witness to focus on those particular areas, not just general domestic violence and generally how a perpetrator thinks or controls a victim.
That's correct. Her testimony is specifically on coercive control, the tactics that abusers use to keep their victims with them, regardless of what they do, and traumatic bonding, to try to explain why a victim would put her interests and needs below someone else's, even her own safety, even when she has the opportunity to do something. And that was the reason for her testimony. And
why wouldn't the expert need to know something about this case to do that?
well, the problem is in these cases, she started opining, actually applying the principles to the facts of this case. She would ultimately be commenting on BP's credibility, and that is uniquely within the province of the jury. And that's why in cases like this, courts have upheld general testimony where the expert has not spoken with the victim, and that's in LaVictor and some of the other cases cited that LaVictor cites. This happens. They don't speak with the victim. They don't interview anyone. They're just giving a general framework so that the jury can kind of understand some of the typical behaviors of domestic violence victims.
You're saying that in the cases that have allowed the generalized testimony, those experts also would not be, number one, not opining on the facts, but would not even know anything about the case or the victim or the defendant?
They purposely will not look at it because they do not want to opine what is the ultimate issue of the jury. They have to decide which version of BP's testimony to believe. Was it the grand jury and all the statements she made close to the day of the incident, or is it what she said in trial?
This is exactly why the problem you just posed, the judges who in their discretion do not allow the testimony, they don't allow it for precisely these concerns, because they're concerned the jury will think that the expert is opining on the particulars.
But in this
Because
case, it's clear
the thing I don't understand, it's such the remand. I don't know what you're afraid of on a remand. I would have thought the government in this case would have filed a motion to say remand it, give them have the hearing. They're not going to get anything. Why isn't that justice? I don't get that. Why are we wasting all this time when the law of the circuit says, as you said, the typical result in a case like this is to remand?
But there's also language in Sitzman that says it's not reflexive. I mean, every case is different.
I know there are cases that go the other way. I've been on the wrong end on one of them, for sure.
Yes, in Sitzman.
You were very nice not to point that out, but in any event, I don't understand why you don't remand in a case like this when you know how fragile the expert, quote unquote, expert testimony is.
Your Honor, we had all this other evidence, especially with regard to the interstate violation protection order. It wasn't just the expert testimony.
That's what you'd figure out on a hearing, on remand.
Your Honor,
I can think of a reason why you don't remand, to put this on the same district judge who has heard all this evidence and knows that if it's retried without expert testimony, I won't say there's not a ghost of a chance. I'll say there's a very slight chance that a jury will not convict this man. And I'm wondering why we can't glean something from the jury in this case. In other words, they did find that he violated the protective order. They mistried on the other two. And to me, that indicates that they're thinking, well, we've heard this testimony about a change in attitude in the victim and so forth. So we don't know if she was kidnapped or not beyond a reasonable doubt. We don't know if there was first-degree burglary. But we do know this interstate order was violated, and that's what he was convicted of.
That's exactly right.
And
Your
it
Honor.
seems to me that the jury did a very good job here of either accepting the expert's testimony or rejecting it and concentrating on the evidence that came from the victim herself, from her roommate, from the neighbor, from their telephone conversation, from the bruises on her body. If there is a case that I think is a exercise in futility to send back, it is this one.
That's correct, Your Honor. And I would just point out that,
You're comfortable with that, counsel?
yes, I am comfortable with that, Your Honor.
Being sarcastic.
I'm taking you at face value. And I'd also like to point out that the B1 charge, if you look at the way the verdict panned out, what I was trying to say, they convicted on the count where her testimony was the least important, or not even important at all, because much of the elements he did not dispute. What they could not reach a verdict on was the counts that depended on her testimony and the credibility of it. First-degree burglary, if you look at the closing argument by defense counsel, he starts out with first-degree burglary, and he says, we're not worried about the assault. We all know the assault happened. But how do you know when the defendant entered the apartment, that he had the specific intent to assault her? Because she testified at trial, BP testified at trial. He walked in, he said, I want to talk to you. He then points out that Ms. Berry was in her bedroom at the time. She did not know what happened in those first few moments until she got up and saw what she saw. And Ms. Talley had seen the defendant push his way in, but she was not in the living room. She could not have heard what the defendant said. So the only people who knew what happened in those first few minutes first few seconds really, were the defendant and the victim, again, as well as kidnapping. Only person who can talk, who knows whether it's consensual or not, are the defendant and the victim. Both those counts, her credibility was key. The jury couldn't reach a verdict on that. What they did reach a verdict on was the count where her testimony really was not important at all. And that is why we think that on this particular record, defendant has not shown a culpable claim. There are no further questions. We've asked that the judgment of the district court be affirmed.
Thank you. Mr. Lecker, why don't you take 2 minutes?
We don't know in the mind of the jurors. We just don't. We do know this. If the issue was, as Judge Childs has eloquently said, consent, testimony went both ways. Why did the government have to put on an expert? Obviously, they were uncomfortable with the situation. There'd be no other reason for them to do it.
You keep focusing on consent. Consent as to what, though? Because earlier my comments were that other witnesses show victim being dragged out. And other witnesses see him violating the order because he shouldn't have been there in the first place. And then earlier you commented on, yes, but this was interstate travel. Well, you start out with the crime at the apartment, and the fact that she's dragged supposedly without consent and then ends up across state lines, why doesn't that make it interstate travel violation?
Well, because you still get back to the ultimate question, mens rea, intent. What was his intent?
You mean intent to have the ultimate outcome that she was across state lines without her permission? So at some point it changed?
Intent to go outside, and she didn't want it. They didn't want to have it. See, this is, again, this is only demonstrating the difficulty of this. So we have a really unexplored issue of an expert who's bolstering the government's theory. What you have here is the victim, BP, the alleged victim, says, listen, I wasn't happy about him coming in, but he wanted to have a discussion. I agreed to have a discussion. We got in an argument. They had a relationship. It was an on-again, off-again relationship. Who knows? Who really knows why they went across state lines? He took her. They drove in his car. She said they walked hand in hand downstairs, and they went out and they went to his car and they went over to Maryland. And there she said, ultimately she testified they had consensual sex. I will admit to you, Judge Charles, these are disquieting facts if you believe a government's theory of a case. Problem with the government's theory of a case is they put the thumb on the scale here. that a jury, we don't know why the jury convicted. We have no idea what was in their minds. What we do know was that there was somebody in that courtroom who was testifying at length as to a phenomena that she said she had observed in her experience, that although she said, I don't know anything about the victim, alleged victim here, I know nothing about the facts, she related a whole host of events that could well have influenced the jury's mind into thinking that this was an example, this interstate transportation charge was an example, an application of a set of phenomena that were not in the record.
See, the problem, counsel, that my colleagues are addressing, which is a difficulty on your side, excuse me. What they're saying essentially to you is, take the expert out, the defendant's still going to easily lose. Just use the record without the expert, given what we're talking about, as Judge Child just recounted, it's going to easily lose. There's no way he can win that case. So there's really nothing, it's almost a harmless error kind of argument. There's really nothing, if it was erroneous, it's discretionary. Maybe it wasn't the best decision to allow the expert in. But what we're essentially posing is a harmless error situation. It's so what? There's no conceivable way on this record that he can win, given what the evidence, the rest of the evidence is.
I think the fact that the jury hung on the other two counts is a strong indication that we don't know what would have happened. But for he might have been acquitted or hung jury on that as well. We can't take that expert out of the equation. It's comfortable to think that you can, but in reality, you know, and I know, and we all know, jurors pay attention, experts. That's the vice with this case.
Okay.
All right.
I'm done.
Thank you.
Thank you.
You were appointed, Mr. Lockhart, and you've done your usual able job in the court. Thank you.
Thank you, Your Honor. Always a pleasure to appear.
Case number 22-1205, City of Lincoln, doing business as Lincoln Electric System petitioner versus Federal Energy Regulatory Commission. Ms. Roby for the petitioner, Mr. Kennedy for the respondent, Mr. Jenda for the intervener.
Is it Miss Roby or Robbie?
Roby, thank you very much.
Good morning.
Good morning. Can you hear me okay?
I can.
Okay.
For now,
For now,
probably change in a minute.
my family tells me I speak very loud, so I think we'll be okay. I do have an issue with eyesight, so. May it please the court, Deborah Roby for petitioner Lincoln Electric. I'd like to reserve 2 minutes for rebuttal, please. FERC's orders denying Lincoln Electric's recovery of its revenue requirement for transmission facilities located in Zone 19 of Southwest Power Pool's transmission pricing Zone 19. Arbitrary, capricious, are not reflective of reasoned decision-making and are contrary to law. This is so because the findings are contrary to the record evidence and are otherwise unsupported by record evidence. They also depart from long-established FERC precedent. First, the orders depart from the principles of zonal rate design. Under a license plate structure, FERC has repeatedly held that it is just and reasonable to allocate transmission costs to the zone in which the facilities are located, and factors such as physical integration with existing zonal facilities are indicative of appropriate zonal placement and cost recovery.
Hasn't FERC also had a lot of precedent that beyond physical location, the cost causation can be for those customers in that particular, who are being served?
You are articulating the cost causation and beneficiary pays principles. That is absolutely true, but the beneficiary pays principles in the context of a zonal rate design find that physical location matters. Those in proximity to the facilities are deemed to benefit from those facilities. What matters is the facility an integrated component of the facilities that support load within that zone. That is the zonal rate
Under
construct.
physical location, tell me about what you mean by benefit, because if it's serving a different zone, you can have a physical location one place, but it's serving customers elsewhere, right?
Well, in the context of an RTO, there is the concept of network integrated transmission service. That concept, as Western noted in its brief, and as we note in our brief, the concept then goes from there's a concept that it operates more like a reservoir than a railroad. Power is injected throughout the region at various points throughout the region, and it is withdrawn throughout the region. Users within the RTO have the benefit of using the entirety of the facilities, but in a zonal rate construct, you pay for the facilities that are located in the zone in which the load is located, the delivery point. You don't pay for the facilities where you source that generation. That is the nature of the zonal rate construct. Here, what FERC did was they essentially created a fiction. There's no question that the facilities are located in Zone 19. There is no question that they are part of the Southwest Power Pool's network service. This happened in 2015 when the Southwest Power Pool was expanded to include these and other facilities of the integrated system parties. This was the creation of Zone 19 in 2015. And once that happened, that zonal placement decision for these facilities was made. And the question is,
Well, why didn't you all move to change the rate formula template in 2015 then?
in 2015, well, it's not unusual for joint owners of facilities to modify their formula rates or to seek rate recovery at different times. There's nothing unusual about that. There's no requirement that you do so at the same time. There's testimony from Lincoln Electric. Lincoln Electric is a relatively small system compared to the larger systems of the RTO. And it got to it when it could dedicate the resources necessary to prepare the modifications to its formula rate to effectuate that decision to place the facilities in Zone 19. There's no no time limitation for doing so.
Are you doubting that they're a legacy facility?
They are not legacy facilities in the context of Lincoln Electric system. This is what FERC relies on in Opinion 494 in reaching its conclusion. But the legacy facilities, it matters what legacy facility means there. Opinion 494 addressed the larger question of rate design within the PJM RTO and the question of whether to depart from the zonal rate design and go to a single postage stamp rate. There's not a question of rate design here. And instead, the commission said that the legacy facilities are essentially the service territory of the utilities that make up the geographic territories of those zones. Here, these facilities are not part of Lincoln Electric system. Lincoln Electric system is located 300 miles away in southeast Nebraska and essentially is comprised of the facilities around the metro Lincoln, Nebraska area. These facilities at issue here, and remember, we're talking about an undivided ownership interest in facilities that are located in eastern Wyoming and western Nebraska. They are not built to support load in the Lincoln, Nebraska area. They are integrated components of the system that is the backbone of the network that comprise the facilities of the integrated system parties, and that includes Basin Electric. They were built as part of Basin Electric system. There's no question that the facilities are already part of the Southwest Power Pool system. Lincoln Electric did not propose to include any new facilities as part of its proposal. It did not ask to expand the system in any way. It sought simply to implement a prior decision that recognized that the facilities are located in Zone 19 and cost recovery should follow that decision. There was no new request for a zonal placement decision.
Now, what happens when physical location and then cost causation conflict?
I don't believe there is a conflict.
Okay, but I'm asking in that scenario,
Sure.
like you have physical location, somewhere else, and it's serving customers elsewhere. You've got some precedent suggesting that the customer should pay, their a portion of the load, even though the facility's somewhere else, and you're arguing that there's a physical location different. But those two concepts can conflict sometimes. So how do we then rectify that?
Well, I don't think with due respect, I don't think they conflict because there's a series of decisions that are made. And the first decision is, where are the facilities located? As the commission has held in the Rochester decision, transmission facilities are not ethereal concepts. They are fixtures that are placed into the ground. They do not move from location to location. So we start with the physical location of the facilities, and the benefits that accrue to those in proximity of those facilities include such benefits that aren't quantifiable, such as reliability and increased pathways to move power. But in a zonal rate construct, which is what is relevant here, the facilities that are located in the zone are deemed to benefit the load that's in that zone. And all load in the zone are deemed to benefit from all facilities in the zone. It does not matter if a facility was constructed in the far northeast corner of a zone and another facility is constructed in the far southwest corner of the zone. They're built for different purposes, but all load is deemed to benefit from those facilities because of the geographic nature of the zones and the zonal rate construct within the RTO. What matters here is the use. The use has changed. FERC attempts to draw a distinction here and relies solely on the original intent. And I've gone into my rebuttal time here, but the concept here is FERC fails to recognize the changed use here. And what matters is when the facilities come into the RTO, is service provided pursuant to the RTO's rules? And the answer here is an unequivocal yes. There's no special treatment being sought here. And Lincoln's use no longer relies on a specific path. It relies on network integrated transmission service, which is the benefit that it receives as being a member of the RTO.
All right, thank you. Mr. Kennedy?
Good morning, Your Honors. Robert Kennedy on behalf of the Commission. In this case, the Commission reasonably found that Lincoln Electric's proposal to have Zone 19 customers pay for their investment in the Laramie River facilities, they had not established that it was just and reasonable. That decision was consistent with the state of the record before the agency and Commission and judicial precedent. In paragraph 38 of opinion 498, which is discussed throughout the briefs and the underlying orders, the Commission explained that when it comes to legacy facilities and cost allocation, it's going to examine cost allocations proposals to make sure they are allocated to, first, those who caused the cost to be incurred, and second, other beneficiaries. And it followed that approach here. With respect to who caused the cost to be incurred, I thought we had pinned down that this had been purchased by Lincoln. This interest in the facilities had been purchased by Lincoln Electric to serve their load in Zone 16. I thought I heard a little bit of equivocation today, but these are in fact legacy facilities. The Commission reasonably concluded that based on Lincoln Electric's response to the deficiency letter, in particular, page 538, where it said it purchased this share in the facilities to serve its load, which is in Zone 16. The Seventh Circuit's decision in Illinois Commerce said it's reasonable to allocate the cost of legacy facilities to those customers who were the reason for the purchase, makes economic sense, and the utility who made this investment had no expectation of recovery from anyone other than its customers for whom it purchased it. But then the Commission went on and examined whether there's evidence in the record that Zone 19 customers benefit from this. And before getting into this, I just want to step back and set the procedural posture here. This is a filing under Section 205 of the Federal Power Act by Lincoln Electric. And under Section 824DE, it is Lincoln Electric's burden to establish that it's just and reasonable. And the Commission went through each of the justifications put forward by Lincoln Electric as to why, the Zone 19 customers should pay. The first, and this is the only justification in their initial filing, they supported it with a declaration from one of their managers, Mr. Florum. This is page 245 of the JA. And what he said is Zone 19 customers should pay because they're already using our interest in these facilities, and our filing just sort of trues up the rate to existing practice. The commission reasonably found, it dug into that question, and it found, based on, again, Lincoln Electric's own statements from SPP, that in fact, Lincoln Electric's share in this facility had not been turned over to SPP's control. Customers had not yet been using it. That was contingent on the commission accepting this proposal. So then the second justification was, well, commission, your precedent says physical location governs. And the commission walked through and explained, and in this regard, I would point the court to the City of Nixon case, which Lincoln Electric submitted in a 28J letter. And in paragraph 10 of that order, the commission said, when it comes to cost allocation, it's a case-by-case analysis that looks to see whether the costs imposed upon the party are reasonably commensurate with the benefits. And the commission walked through the various cases that Lincoln Electric pointed to and said, look, in some of them, there's record evidence that the customers who you want to charge are going to benefit. In Allegheny, there was record evidence that had this particular facility not been built by party A, the local utility would have had to build it itself. In the City of Nixon, we heard discussion of integration benefits and things of that nature. And certainly it's true that facilities can benefit those around it. I mean, that's obvious, but there has to be evidence in the record that shows something that allows the commission to weigh the costs and the benefits. In City of Nixon, there was testimony, not just a statement that they're integrated, there was testimony establishing why that mattered. It allowed for more efficient planning. The integration allowed for the local utilities to avoid reliability problems. There was testimony that it opened up additional paths to generation. All of that's lacking here. And again, this sort of gets us back to where we started with the Seventh Circuit's opinion in Illinois Commerce. The first half was about legacy facilities, and the commission's decision here sort of follows that. The second half, the Seventh Circuit faulted the commission for doing just what Lincoln Electric is doing here, just invoking general statements that these are backbone facilities, that they have integration benefits without putting any sort of meat on the bone that will allow some sort of balance.
As I understand it, the opposing counsel's argument is that there are changed circumstances. So even if the legacy notion and location notion are viable, her argument is that the circumstances have changed. You seem to say the commission said that's not right. I'm looking at what they said. We acknowledge Lincoln Electric's representations that its use of its share in the LRS facilities has changed over time, and that Lincoln Electric currently relies exclusively on network service to deliver the LRS facilities output to Lincoln Electric. So isn't it credible? Isn't what she said credible, that circumstances are not what they were initially?
No, I think the commission did acknowledge that they are taking network service. The commission also found that currently there is evidence in the record indicating that Zone 16 customers are still the beneficiaries of their share. It has not been turned over to SPP, so we know Zone 19 customers are not benefiting from it. Lincoln Electric is recovering under its investment in this facility under its retail rates from Zone 16 customers, which suggests they're still benefiting. And third, Lincoln Electric has what we call a grandfather transmission agreement, pre-existing agreement that's brought in, and they are able to take service under the, it still exists notwithstanding the global tariff. And Lincoln Electric acknowledges at page 651 of the JA that allows them to avoid certain congestion charges, which also will benefit their load in Zone 16. But yes, certainly circumstances have changed, but there must be some showing that those changed circumstances warrant imposing these costs on Zone 19 customers. The evidence is SPP, the commission found in paragraph 37 of the initial order that there's no need for this capacity in Zone 19 right now. Those particular facilities are already, the two pieces that have been turned over to SPP, there's already excess capacity in standing alone. Lincoln Electric would only add to that surplus, and there's no record evidence showing how that would benefit Zone 19. And remember, turning this over to SPP, allowing it any excess capacity to be sold, that doesn't mean that Lincoln Electric just gets some money when the excess transmission is used. It would mean the way this rate design works, if it's placed in Zone 19, those Zone 19 customers would have to reimburse Lincoln Electric for their investment, whether it's used or not. And yes, there is a zonal rate design that's premised on the notion that facilities work together and provide zonal benefits. But before a facility is placed in a zone, there has to be a demonstration, record evidence, that it benefits the parties who are being asked to pay for it. And that's what's lacking.
All right.
Thank you, Your Honors.
Thank you. Mr. Janda?
Thank you, Your Honor. May it please the court. Sean Janda for the Western Area Power Administration. I'm happy to address any questions that the court might have, but otherwise I'd just like to make 3 brief points. So first is, I think it can be a little bit easy to get lost in the technical complexity underlying this case. But at its core, what's happening here is, I think, quite simple. Lincoln Electric in 1977 made a decision to invest in these facilities to benefit Lincoln's customers in Lincoln, who are now in Zone 16. And for decades, Lincoln used the facilities to deliver benefits to those customers, used them basically as a railroad, to return to that metaphor, to deliver power from these generating facilities to their customers in Lincoln, Nebraska. And now that Lincoln has joined the pool, the facilities have joined the pool, Lincoln has apparently decided it doesn't want to or need to use them in that way anymore, and it wouldn't like to continue paying for them. But Western Area Power Administration, the other Zone 19 customers, had nothing to do with Lincoln's decision to incur those costs originally, are not benefiting from the facilities today, have no use for the facilities today. And I think FERC, looking at that record, made the very reasonable determination that it would not be fair, it would not comport with the cost causation principle to allow Lincoln to foist those costs onto Zone 19 customers when they're not using the facilities, benefiting from the facilities, and had nothing to do with the decision originally to invest in the facilities and incur those costs. Second is, to the extent that Lincoln is suggesting that there's something special about the physical location of the facilities that should dictate the outcome here, I do think it's important to recognize that that bridge has sailed. The tri-state investment in the exact same facilities has been allocated to Zone 17. FERC talks about this in FERC's brief. Zone 17 is where tri-state serves customers. It's where the sort of beneficiaries of tri-state's investment in these same facilities has been allocated. The Eighth Circuit approved that allocation in the MPPD case that's cited throughout the briefs. And so I don't think there's anything sort of special or magical historically or in the commission's or this court's precedent about physical location that would override the question of who actually has been benefiting from these facilities for the last 45 years. And then third, again, just very briefly, I think to the extent that there's any questions in the court's mind, it is important to remember the sort of doubly deferential standard of review here. Lincoln bore the burden originally of proving that this proposed change was just and reasonable. FERC rejected that, and Lincoln now bears the burden in this court of showing that FERC's decision not just is wrong, but is arbitrary and capricious under a very deferential standard of review, using or in the context of very sort of complicated and technical questions about electricity management. And so to go back to your question, Judge Childs, even if there might be different strands of precedent pointing in different directions in this case, I think FERC went through all of the precedents cited in really an admirable way and determined that in the particular context of this case on this specific record, that the sort of just and reasonable thing to do is not to allocate all of the costs, the sunk costs of these facilities to the Zone 19 customers. And so even if, again, there might be some precedents or principles that might point in the opposite direction, at the end of the day, I think FERC's weighing of that evidence and ultimate conclusion is entitled to substantial deference from this court in this court.
I do have a question, and that is, I wasn't familiar with these federal utilities, and how many are there in the country? Is TVA one of them, or is that?
So I'm not sure exactly how many there are. I think TVA is one, the Bonneville Power Administration is one, the Western Area Power Administration is one, and they, as a general matter, market and sell federally generated hydroelectric power from sort of all the dams and power structures that you can think of.
So you're basically a competitor, competitor utility, I guess.
I'm not sure that we compete on a utility front with Lincoln, for example, because I'm not sure that Western Area Power Administration actually serves customers in Lincoln. Lincoln serves customers, but we sell power to mostly, I think, to statutorily designated preference customers, Indian tribes, state and federal agencies, municipalities, cooperatives, things of that nature.
Thank you.
Thank you.
Let's see, Ms. Roby, why don't you take 2 minutes?
Thank you very much. I'd like to address a few items here. First is, it's important to understand that what Lincoln proposed was not a different zonal placement decision than one that had already been made. When facilities are placed, it happens once. It doesn't happen every time a joint owner comes in. The tri-state decision didn't involve zonal placement of Lincoln, of the facilities themselves. That was an election by tri-state to depart from what had already occurred in 2015. There's nothing in the tariff that prevented tri-state from seeking a different cost recovery from what FERC had already proved when those facilities were placed in the first instance. But Lincoln Electric is not making an election to depart from that decision that was made in 2015, which is why its proposal was about the mechanism for recovery. What FERC did was FERC never got to the mechanism for recovery. Instead, we're going to evaluate Lincoln's share as though it is a separate facility that must be evaluated brand new, as though it's new to the system. And that is a fiction. It is simply not true. It's not what happened. The second thing is, with respect to the degrees of physical connection in the city of Nixa, the city of Nixa decision, again, is a zonal placement decision. And that there is an evaluation of the benefits to determine who benefits from the physical facilities. That, again, is one of those decisions that happens at the time the facilities come into the RTO. These facilities are not new. The facility is already a part of the Southwest Power Pool RTO. And the Southwest Power Pool has said, as far as excess capacity, the commission has never made a determination, as far as I'm aware, that whether or not you may recover from a particular zone depends on how much capacity is available in that line. The commission doesn't separate out capacity and treat it as though it's a separate facility. This is the nature of multi-owner transmission pricing zones as well. The zone 19 started with the initial integrated system parties, I think 3 or 4 parties. There are now 20 transmission owners that are listed in zone 19. Each one of them constructed facilities for the benefit and use of their own systems. But now everybody in the zone is paying for those. If the original intent theory were central to this evaluation, there could not be 20 transmission owners all sharing in the costs that exist now in zone 19. There could be no multi-owner transmission pricing zones. The focus on the original intent to the exclusion of all other relevant factors is where FERC erred here. And that cannot be upheld. It would destroy the very nature of the zonal rate construct. You couldn't have multi-owner transmission pricing zones. Thank you very much.
Thank you.
Case number 23-7012. David W. Noble Jr., appellant, versus National Association of Letter Carriers, AFL-CIO et al. Mr. Oleko for the appellant, Mr. De Chiara for the appellees.
Oleko, good morning.
May it please the court, my name is Dan Oleko on behalf of David Noble. This case concerns the proper interpretation of Section 401C of the LMRDA, which requires unions to comply with all reasonable requests of any candidate to distribute campaign literature by mail or otherwise in aid of such person's candidacy. The statute serves a special purpose. It was designed to offset the incumbent's inherent advantage, including the incumbent's control over the union press. To effect this special purpose, courts must broadly interpret Section 401C to affect that purpose of the statute. But the district court adopted an overly narrow interpretation of the statute, construing it to require unions only to coordinate the delivery of a candidate's standalone, already printed materials. The district court also erred in concluding that Noble's request was unreasonable as a matter of law. Nothing in the pleadings, which should have been liberally construed in favor of Noble in light of his pro se status below, showed that his request was per se unreasonable.
Should we just be looking at this as to the request in this case? And what I mean by that is that the union has a rule that it will allow print, of the campaign materials for a particular issue. Obviously, Mr. Noble wants something earlier. And then you're also focusing on the word reasonable. So can reasonable mean we want to announce our candidacy a year earlier when, they don't do the publications for campaign issues until a particular issue?
Well, so I think reasonableness is the standard. And so if you're going to ask for your campaign literature in every single publication for all 4 years, I think that is probably unreasonable. But Mr. Noble was requesting that his ads be placed starting in the February issue leading up to the election. There was no finding that doing that in and of itself was unreasonable or was a burden on the union. The district court concluded that Noble's request was unreasonable because it supposedly altered the nature of the magazine, but the postal record allows that. It allows it once every 4 years. The only question is whether violating NALC's policy of having such advertisements once every 4 years makes Noble's request unreasonable. The Brown case makes clear that that conflict does not make it unreasonable. A request to distribute campaign literature is not per se unreasonable simply because it conflicts with a union rule. The reasonableness inquiry turns on certain factors, as the Supreme Court stated in Brown, including whether the request would cause administrative or financial hardship to the union, or whether it would discriminate against any other candidate. The district court didn't address either of those factors. NALC didn't argue either of those factors below. There's simply no facts in the record that would show that those factors weigh in favor of NALC. In fact, Noble's request wouldn't cause any financial hardship to the union. He offered to pay for it. It wouldn't discriminate against any other candidate. He didn't ask NALC to say, oh, post only my campaign literature, but not anybody else's. He just wanted to have an equal opportunity to advertise his candidacy to the union members as the incumbents. But rather than considering these relevant factors, the district court relied on limitations placed by other courts on 2 other provisions of the Act, the similar distribution provision and Section 101, which guarantees union members free speech rights. But these provisions, they don't include a reasonableness requirement. Moreover, Section 101 is made subject to reasonable rules in the union's constitution. It's not absolute. And as the Supreme Court stated in the Brown case, Section 101 is different than Section 401 because of Section 401's special purpose. Further, the limitations.
How do we go about defining distribute, publish, or otherwise? Like, have you found any particular cases that define that? Because you're suggesting that the terms essentially are mutually exclusive.
I don't think they're mutually exclusive. I think they're the same. I think that NALC says that distribute doesn't mean publish, but the definition of publish makes clear that publishing is a type of distribution. The definitions say that publish means to disseminate to the public, to produce or release for distribution, to issue the work of an author. So there's no real distinction there. In fact, you can distribute something in many different ways. It doesn't have to be a standalone thing. If you distribute a law journal to a bunch of law schools, you're really distributing all those articles in the journal to the law schools. They're just bound together in a single volume. And the statute itself does not restrict the method of distribution. It says by mail or otherwise, and it must be interpreted broadly. That broad language certainly includes a request to place an advertisement in a magazine. So while the term campaign literature isn't defined by the statute, it must be also interpreted broadly. None of the definitions cited by the district court limit campaign literature to standalone already printed materials. In fact, the definition of literature means printed material of any kind, including advertising. So Mr. Noble's request to place an advertisement falls squarely within that definition. The term campaign simply describes the type of literature we're talking about. While leaflets, handbills, and circulars are certainly examples of campaign literature, there's nothing in the statute that limits campaign literature to those specific examples. Indeed, the Department of Labor agreed that emails qualify as campaign literature, and that's not disputed by now.
Why is it unreasonable for the union to enforce a rule that says for all members, any campaign literature can be published on the prescribed period? That's it. And if he wants to breach that rule, isn't that an unreasonable request?
It's not. As the Brown...
Is the union's rule reasonable?
Well, the issue, as the Supreme Court stated in Brown, the issue isn't whether Noble's request violated a union rule.
If the rule is reasonable?
Even if the rule is reasonable.
The Supreme Court said even if the union has a reasonable rule.
Yes.
It can be violated.
It can be violated as long as the request itself is reasonable. And here we're not talking about some request to place, as we were discussing earlier, an ad in every single issue in perpetuity. We're talking about the request to place an ad in issues leading up to an election.
Why do you think that's reasonable as opposed to the union's rule? He's writing a different rule. I didn't realize the law allowed the members under this provision to write a different set of rules because in their view, it was more advantageous when in fact the union's rule was not unreasonable. I don't think the Supreme Court said that. I'll certainly go back and look at that. If you tell me that's what your reading is, I'll trust you to read it. I didn't realize that's what the Supreme Court said.
That's my understanding of the Brown case, Your Honor. But I will say, this case...
union member can adopt, in my mind, a different set of rules, which I think are reasonable, and apply them or have them applied in place of a reasonable set of union rules. Wow, really? Is there some particular sentence you recall that says that?
I can address that in reply, Your Honor.
I'll look it up.
But I think the key point is here, the district court did not find that it was unreasonable in and of itself to post, it didn't make any factual findings regarding a hardship to the union, regarding an expense to the union, regarding some discrimination. The only basis for the district court's decision was on the conflict with that rule. And I respectfully submit that that is not enough, and that does not make Noble's request per se unreasonable. Save the rest of my time.
All right. Mr. De Chiari.
Good morning, Your Honors. Peter De Chiara for the National Association of Letter Carriers.
Okay, now let me take you right back to a question I left with counsel because he does have language that the Supreme Court used, and you can tell me what you're reading of it. The text, structure, and purpose of Title VI all support the conclusion that our inquiry should focus primarily on the reasonableness of the candidate's request rather than on the reasonableness of the union's rule curtailing the period in which campaign literature may be mailed.
That is correct. This Supreme Court articulated the test in Brown as an inquiry as to the reasonableness of the candidate's request, not the reasonableness of the union's rule. That's correct. However, here, Mr. Noble's request, well, first, did not square with the statute because it was a request for publication of his campaign ads, not a request for distribution of his literature. But even if you get past that.
We can go there if you want, but that's a really strained reading of the statute.
But okay, the second.
I realize what the district court did, but I mean, if that's your principal way to survive on this appeal, I don't find that persuasive. He's surely within the general parameters of the statutory protections, and start talking about these various forms of publication. It gets me nowhere anyway. Go ahead.
The reason his request was not a reasonable request under the statute, well, there were a couple of reasons. One is that it was unreasonable because it would create a constitutional harm to the union. It would compel speech by the union. The Supreme Court in the Miami Herald case said that a newspaper cannot be compelled to publish candidate content. In that case, you had a Florida statute that said a newspaper had to compel a reply by a candidate, and the Supreme Court said.
But under the circumstances of the union rule as it exists in publishing in a particular issue, you're allowing campaign ads to be published in that issue. So whatever the ad says, you're just posting it. You're not agreeing with them, you're just posting.
Exactly that argument was made in the Miami Herald case. The argument was made that, well, it's not a First Amendment violation to require the Miami Herald to publish candidates' content because the Miami Herald is free to say whatever else it wants. It's just hosting. And the Supreme Court exactly rejected that argument. In fact, that argument can be made in every compelled speech case.
Well, how do we look at the Rumsfeld case?
The Rumsfeld case is a case that was not about speech. It was about content. It was about whether law schools were required by statute to allow military recruiters on campus. And both in the case itself, but also more recently this summer, the Supreme Court in the 303 creative decision addressed Rumsfeld. And in the Supreme Court's recent 303 creative decision, the Supreme Court indicated that Rumsfeld was primarily a conduct case, not a speech case. And to the extent that speech was involved, it was incidental.
Now,
So
does it matter here that this is a newsletter by the union as opposed to your example of a newspaper owned by someone else?
it does not. And let me give you an example. In the Pacific Gas case, which was a Supreme Court case holding that a utility, a gas utility, which put out its own private newsletter. It was a house organ of the utility. It was not a commercially available newspaper, and it was required by, I think, a California regulatory agency to post a notice in its organ, in its house organ, in its publication. And the Supreme Court said that was a case of unconstitutional compelled speech. So it doesn't have to be a commercially available, a commercial newspaper. It can be a publication of an association. And the reason is because any publication is a curated, edited, a product of curation and editing. The union's magazine doesn't edit itself. The union makes decisions about what it should say, how it should say it, and most importantly, what it should not say. Those are all First Amendment protected speech activities. And so to hold that the union has to compel the union to publish Mr. Noble's ads whenever he likes, and would violate that First Amendment principle. And let me get to the second harm. There's the constitutional harm, but there's also the harm that if this court ruled for Mr. Noble here, it wouldn't just be Mr. Noble And it wouldn't just be the February 2021 issue. It would allow any candidate to put their paid ads in the union newsletter whenever they want. And each election cycle, this union has about 24 positions up for election. And the union has about 280,000 members, most of whom are eligible to run. So the effect would be pretty much any union member who is interested in running for office would have a paid column in the union magazine. It would crowd out, it would turn the union publication, and I would invite the panel to, your honors, to look at the publication. It's in the record. It's a very straightforward news you can use kind of publication. It would convert that journal into a political rag, full of political disputation. And the Supreme Court and the lower courts have said that it's up to the leaders of the duly elected leaders of the union to determine the content and the tone.
Are there findings here on administrative and financial hardship?
Let me address that, Your Honor. In Brown, the Supreme Court, first of all, let me say what Brown was about. Brown was a simple case. It was about whether a union can say that to a candidate, you don't have 401c distribution rights until the nominating convention. And the Supreme Court said, you can't restrict 401c rights like that. There was nothing about publications. There was nothing in that case. And the two factors that Brown cited, financial and administrative hardship, were not exhaustive. Those are not the factors that apply. Those were just the relevant factors in that case. Here, since we are dealing with a publication case, there are other considerations, which I've just articulated, that explain.
Their findings was my question.
I'm sorry?
I'm sorry. Are there findings?
Are there findings in this case?
On financial and administrative hardships?
Well, there are no findings because this complaint was dismissed. But the union doesn't allege financial or administrative, or does it? Our defense is not financial or administrative.
Well, you just argued it.
No. Let me please try to, allow me to clarify.
Pitch, and I'm looking at the Supreme Court's decision, and you're pitching it to the Supreme Court's decision. That's why I'm wondering, are there findings here to support it?
What I'm saying, Your Honor.
The union does not contend, for example, that the respondent's request called administrative or financial hardship to the union, or the discriminated against any other candidate, et cetera. So they're putting the burden, the language in this case sweeps more broadly than just the facts. It is construing 401c, and it puts a pretty heavy burden on the union in that case.
Your Honor, what I'm saying is those factors that are laid out in Brown are not the exhaustive, are not the only factors that a court can consider.
All right, what are the other factors?
In this case, the two factors that I articulated. One is the constitutional harm of compelled speech, that where Miami Herald and Pacific Gas are directly on point. So it's not a financial or administrative harm, it's something even worse, it's a constitutional harm. So that's one. And then two is what I explained, which is that if the court opened up the union publication to the 200,000 members of the union to publish whatever they want, whenever they want it, in the publication.
That's a hardship burden.
Okay, so I'll put whatever label.
I mean, that's a hardship.
Okay, then I'll take that. Whatever label one.
Take it now. There's no findings on it.
Well, there are no findings.
First of all, the case, I don't know that the case has been posed that way, that's exactly what the plaintiff is saying, so that you could really have a hardship burden to show. I mean, a hardship evidence to support a hardship burden. I'm sorry, my throat's killing me. So that's what I'm trying to figure out. Where are you going? What's your theory here? Supreme Court, the language in Brown is not friendly. And, so I'm trying to figure out how you're meeting that burden. And the First Amendment, the NLRB requires employers to post things all the time, and employers don't have no First Amendment protection against that. They have to post what the NLRB says to remedy a violation. I don't know why here, when you have a requirement that the union, which is in an advantaged position because it's in power, the union leaders are in power, and a court finds, no, you can't use that to your advantage and block out those who want to oppose you. That was the settled law. I can't imagine a court can say, you know, he made a reasonable request to stick an ad in your newspaper.
If I can address first the NLRB cases, Your Honor, in 303 Creative, the Supreme Court just this past summer addressed those cases and distinguished them. And what it said was that in those cases, the employers were required to post, quote, purely factual and uncontroversial labor law information from the government. And the Supreme Court sort of cabined those cases, sort of created an exception, if you will, for that sort of a situation. That is not at all the situation.
The union would not be endorsing the campaign material. It would simply be posting it.
It's the same in Miami Herald. The Miami Herald was not endorsing the candidate's content that it would have been required by the Florida statute to publish. It wasn't endorsing it. It would have been clear to everyone in the world it wasn't the Miami Herald's opinion. But nonetheless, the Supreme Court held that it was unconstitutional, compelled speech, and the same, the newsletter.
In the face of a 401c prescription, Miami Herald involved that kind of legal requirement, and they're saying in the face of that, it would still be unconstitutional. In other words,
the Constitution hasn't changed. In fact, the Supreme.
No, I understand that. I'm saying you can view constitutional claims in context. You must view them in context. So the question would not be as an abstract matter whether you can force someone to publish something you don't want to publish, but rather when the law requires you to do something, is the law unconstitutional because it requires that? I read 401c saying in a number of situations, the union may be required to allow a candidate to post messages that the union would rather not have posted.
What I'm saying, Your Honor, is if 401c were interpreted as urged by Mr. Noble to require a union publish his ads, that would be unconstitutional. So I'm not suggesting the court has.
401c is unconstitutional because I think that's what 401c says, that you have to allow the remedy. Suppose the union said, suppose the case here was, no, you can never post anything in our newspaper. Not once every 4 years, never. No member, no candidate can ever post. Is that permissible?
Absolutely.
Yeah.
It was compelled speech. The union here very fairly allows every candidate in the issue before the election to put in their ads.
And the union doesn't judge what that posting is.
I'm sorry, Your Honor?
The union doesn't judge what that posting will be.
No, of course not.
But if that's the case, you keep talking about compelled speech versus posting.
Right.
But you don't argue that it's compelled speech for the time that you actually will publish.
Because there's a big difference between being compelled to do something and doing something voluntarily. The union voluntarily decides every 4 years, we're going to open up the issue to allow candidates to publish their campaign ads. But what this case is about.
The difference between the Miami, I mean, I have to think this through further. The difference between this kind of case and Miami Herald type case is the unions and employers in these situations are governed by federal law. The union exists in a certain way because the federal law credits this existence and gives them certain rights. The union is nothing more or less than its members. So its members have those collective rights as well. And so we're looking at an entirely different situation. It's not like someone coming into a newspaper, that person coming into the newspaper doesn't own any piece of the newspaper. The union members here do own a piece of the union. They are part of the union, and the law says, as part of that collective, here's the way it operates, because the law is protecting both sides with certain rules. That's not Miami Herald. That's not the same situation. And yes, the courts probably can, in some situations, give a remedy, if it's appropriate, that might say you have to host certain contact because the law allows you to have newspapers and publish them. And so we are putting certain limitations on what we're going to allow. You're stretching Miami Herald too much.
Your Honor, the district court in this circuit has 2 times before addressed the very question here about whether or not 401C allows for publication in a journal, in the Camerata case and the Jablinski case. And there, the question was whether 401C allows the requested remedy that the plaintiffs were seeking, the candidates were seeking there, to have their material published in the magazine, in the union's magazine. And the district court held that the statute did not allow that. It also, by the way, held that that remedy would violate their First Amendment rights. So we have.
Did we endorse that view?
Excuse me, Your Honor?
Did we endorse that view?
I don't believe that went up.
I'm not aware of it. If we did, then you're.
No, I'm not saying they're
On the
binding.
circuit, it's an opinion.
I'm not saying it's binding precedent. I'm just suggesting we have now three district court decisions over the course of several decades in the lower court, all agreeing that 401C doesn't allow the remedy or what the plaintiff is seeking here, which is a publication in the union's journal. Let me go back to the point that that Mr. Noble owns the National Association of Letter Carriers.
He doesn't own it. I'm saying he's part of the protected group.
He's only a member.
And he pays his dues.
And he pays his dues, I assume. I don't know that he
certain
does.
rights as a consequence.
Right.
And the union exists because the law allows it to exist. And he's part of that group.
That is all indisputably true, Your Honor. But what is not true is that Mr. Noble or any member of the union owns the union's magazine any more than they own the union's headquarters building a few blocks from here. The union as an association is recognized under law as a separate entity, as any membership association is. And just because you're a dues-paying member doesn't mean you get to say what goes in the association's magazine any more than, I mean, I'm a tax-paying member of the United States of America, which is a democracy, but I'm not allowed to decide, the color of the paint on the walls in the federal courthouse. It doesn't translate. He does have certain rights. Those are the rights granted by the statute, but as there is never, in the 60 years since the statute has been enacted, there has not been one case that supports Mr. Noble's theory that Section 401C gives a union candidate a right to publication in the union's journal.
Maybe that's because there haven't been any violations.
All right.
Your Honor, if I may just address that.
I don't know what to make of that. It may be that most unions understand you accommodate reasonably, because that's what the statute says. We're only talking about reasonableness.
The statute's been around.
The union has the opportunity to determine whether or not, or show the court whether or not it would be unreasonable to allow this. And that's probably the way it plays out in most situations. So the fact that there's no case law, and I don't know what to make of that. Maybe that everyone understands this.
Well, there have been many union elections in the last 60 years.
Right, and it may be that other unions reasonably accommodate requests. I don't know what reasonable would be. I mean, I'm trying to think this through in terms of your First Amendment your First Amendment argument is very, very sweeping. Well, you've conceded that. You're saying this doesn't exist. You're saying the statute does not exist. Well, that's a big step. Okay.
Thank you.
All right. Thank you. Why don't you take 2 minutes?
I want to address a few of Nauk's arguments here with respect to the unreasonableness or the supposed harms. The district court didn't make any findings supporting a First Amendment harm here. District court didn't make any finding that complying with Mr. Noble's request would somehow open the floodgates, and Nauk didn't argue that below. And certainly the district court didn't find that it would necessarily turn the publication to campaign literature. But But turning to the actual arguments, this isn't a free speech issue. Noble's request doesn't require NALC to say anything. Noble's not asking NALC to create anything for him, any messaging. He's just asking NALC to post his already made campaign advertisement in the magazine. It's obvious if you look at the advertisements that it's not NALC speech. You look at appendix number 55 and 56, those are some examples of Mr. Noble's campaign literature. They're clearly not by NALC. Noble's interpretation of the statute would merely require NALC to host candidate speech, which is permissible since it doesn't prevent NALC from responding to that, doesn't dilute or interfere with the incumbent's own messaging. Further, this case is unlike Miami Herald. It's unlike the Passaic case. It's unlike Pacific Gas. Those cases all required newspapers and newsletters to publish particular dissenting views. Noble's interpretation of the statute would not apply to only certain dissenting viewpoints. Under his interpretation of the statute, any candidate, incumbent, dissenter, could make the same request. It applies broadly to all candidate viewpoints. So those cases are plainly distinguishable, including for the reason that the union publication's completely different character than a commercial publication. But here, the First Amendment depends on critical facts regarding postal record, facts that were actually not before the district court. The Miami Herald case was premised on the statute's intrusion into the role of editors who make critical decisions about the content of the paper. And I believe NALC just made an argument saying, oh, the postal record, they have editors, they make these critical decisions. Well, there's nothing in the record that supports that because this case was dismissed at the Rule 12b6 stage and nothing in Noble's pleadings support that. It would be improper to look outside the pleadings at this stage, especially for the first time on appeal. In the 303 case, I will just say the parties stipulated to these critical facts that aren't before you right now. They stipulated that the plaintiff's website was original and customized, and it contributed to the overall message of the plaintiff. They also stipulated that the websites and graphics of the plaintiffs were expressive. None of those facts are before us right now. There's no finding, and this court should not resolve those factual issues for the first time on appeal. Now,
You need to wind it up.
I'll wind it up. I just wanted to say with the floodgates, there's no facts based on the record that this is going to somehow open the floodgates. Nothing in the complaint supports it. It's not a proper consideration on a motion to dismiss. And finally, this is not going to change the character of the magazine. The magazine already allows these types of campaign literature. We just request that they allow them in a reasonable time period surrounding the election besides just that one issue. Thank you.
Thank you.